NSA because leak Edward Snowden has been on something of a public relations offensive this past week. He gave an interview to the Washington Post in which he said this: "For me, in terms of personal satisfaction, the mission's already accomplished. I already won." And he had a Christmas message. Yes, a Christmas message for the people of Britain.
Together, we can find a better balance, end mass surveillance, and remind the government that if it really wants to know how we feel, asking is always cheaper than spying.
Congressman Schiff, are you moved by the Edward Snowden Christmas message, and has he performed a public service, as he seems to think?
I'm not moved by the message at all, and I think there's a real irony here that he's giving this message from one of the most foremost big brother states in the world, where he is living without any privacy because there's no right or expectation of privacy in Russia whatsoever. So I'm not moved by this at all. You know, he has kindled an important public debate, but frankly, I think it came from a mixture of motivations on his part. And I think he should have stayed in the United States and been willing to stand up for his beliefs if that's what motivated him. I think that would have demonstrated the courage of his convictions. So I don't find his message particularly moving or appealing.
Congressman Rogers, in the Washington Post interview, Snowden asks and answers the question, who elected him to reveal all of these government secrets? And his answer is that he says that it was the overseers of those programs. Let's put up specifically what he says. Dianne Feinstein elected me when she asked softball questions in committee hearings, he said. Mike Rogers elected me when he kept these programs secret. He says he's doing the job that you failed to do.
Yeah, well, you have to remember this is somebody who had a troubled employment history. Ran to China and Russia. He stole American classified documents that, because of their release, jeopardizes our troops in the field in places like Afghanistan, and has allowed nation states, Russia, China, and others, to have valuable insight in the way our intelligence services operate to collect information to keep America safe. That's who the messenger is, number one. Number two, the most recent court case, this happened just a few days ago by Judge Pauley, laid out very succinctly the oversight of the NSA program. And I think there's a big confusion about that this is Obama's program that he instituted when he was in office. This is a program that was initiated after 9/11 because we missed a big piece of information. So both of the chairs of these committees, all of the members of these committees are fully briefed on all of these actions. It is our job to make sure that they comport with the law. We do that. We take that very seriously. I think all of that happened, and I think this most recent judicial ruling is important for one reason. It reinstituted faith in the institution of judicial oversight, congressional oversight, and the checks and balances within the executive branch.
I want to talk to you about this because you can, depending on your opinion, you can just wait for a judicial ruling and you can find some backing for it. Because let's talk about this mass NSA collection, metadata collection of billions of Americans' phone records, who they called and how long the call lasted, not the content. We want to emphasize that. Now, in terms of rulings, in just 11 days, we had one federal judge who called that practice of metadata collection almost Orwellian and likely unconstitutional. And then on Friday, we had another federal judge call it lawful and the government's counterpunch to al-Qaeda. Congressman Schiff, do you agree with the congressional panel, because they came out with their 46 recommendations along with the two judges, who say rather than have the government hold on to these billions of metadata, that it would be better to have the phone companies or some other private entity hold on to that information?
Chris, I do. I strongly agree with that conclusion, and you know, some have diminished the report by saying it's just the work of a bunch of professors. We have to remember, you know, Mike Morrell was the acting director of the CIA, Richard Clark, a long experience in counterterrorism, transcending administrations of both parties. Interestingly, the two judges that you mentioned, both appointed by presidents of different parties, and contrary to what people might expect, the Clinton appointee upheld the program and the Bush appointee said it was unconstitutional. I actually find confidence that in those rulings, in the sense that those judges didn't feel bound by the party of the president who appointed them.
Congressman, if I can bring in Congressman Rogers, Though, on the specific issue of who should hold on to these records, because there seems to be a general agreement that they need to be held on by somebody. The haystack that you... Real quickly.
If I could just address that very quickly. The reason I think the program ought to be restructured is that we can get the same national security information that we need without the government obtaining millions and millions of records. It doesn't need to hold. The phone companies already hold these records for a period of time. We can go to them when necessary, as the task force found. We can have an exigent circumstances exception where we can get those records immediately. Otherwise, we can go to the FISA court in advance. So we can both protect the country and protect the expectation of privacy. And that's the course that we ought to take, and that's how we ought to restructure the program.
We're running out of time, sir, so let me bring in Congressman Rogers. The interesting thing is, since that recommendation came out, both the intel community and some privacy advocates say, we're not crazy about the government holding it, but we think the idea of some private entity holding it would be even worse.
Yeah, it opens it up to privacy concerns across the board. And so there is no such oversight. And again, the reason that decision was important, it went beyond, it looked at all of the oversight issues in the ruling and in the judge's opinion. Very important.
But you lose another ruling that directly disagreed.
But if you read that ruling, it wasn't based, it was not a substantive ruling. Why he stayed his own ruling. He said this is probably going to get overturned. Why? 15 judges, 36 rulings, all of them upheld that this program is lawful and meets the Fourth Amendment test. And then you have hundreds of appellate decisions over since Maryland v. Smith that uphold the underpinnings that these are business records, non-content, no names, no addresses. That, I think, is an important distinction. So I think the foundation of the legal argument is there. And what we have here is you're going to take away the safety of what is well overseen, locked away in a vault, very, very strict oversight on who gets access to even check a foreign number coming into the United States. And this is what's important. After 9/11, we missed a foreign call coming into the United States. They said, how do we fix that? This is the way they decided to fix it, and you have all the levels of oversight to make sure it's safe. It goes to the private companies. You're going to have a government-mandated scheme. No such oversight the way we have it at the federal government.
Well, this is going to be continued, as we should point out. The president on his Hawaiian vacation is studying, I'm sure, the court decisions, the varying court decisions, as well as his independent panel's rulings or recommendations, and he's going to come out in January with a new set of guidelines. Congressman Rogers, Congressman Schiff, thank you both so much for joining us, and we'll stay on top of the surveillance debate. Thank you, gentlemen.
Thanks, Chris.
Up next.